Good morning, and welcome to Talk of the Town on 99.7, 1450 WHTC and WHTC.com.
And we welcome you to Talk of the Town for this Wednesday, September 30th. I'm Gary Stevens. We'll have a little bit of open line following the 10 and 11 o'clock news blocks. Patty Vandenberg will be joining us in about an hour. What's new around Holland? And we'll get our update from the Holland VFW Post with Vern Blaukamp. Day after it was National VFW Day yesterday. But our first half hour is devoted to the upcoming November 3rd election on a more local scale. She is running for the 58th District Court Judge seat that will be vacated by the retiring Susan Jonas. She is also a current Ottawa County Assistant Prosecutor. She is Juanita Bocanegra, and she joins us from her offices. And we say good morning, Juanita.
Good morning, Gary. Always a pleasure to be here with you.
Glad you are with us. And if you have a question about her candidacy or about the prosecutor's office, Juanita will be happy to answer it at 395-1450, 395-1450. When we chatted last week, we discussed a situation involving grand juries with the decision and an announcement by high noon in Kentucky to disclose the grand jury proceedings in the Breonna Taylor case. Juanita is going to rejoin us today, hopeful of being able to answer some of the questions involving a grand jury in our neck of the woods. Are you able to help us out with that, Juanita?
Hopefully, Gary. You kind of put me on the spot last week, and I said I don't have all the answers, but I promise I can get them. So I did do some reading. I did a little bit of research, and hopefully I can answer those questions for you.
Now, first of all, in Michigan, what is the criteria for impaneling a grand jury in a state situation? It's different with the feds, but in a state situation.
Correct. So in federal cases, first of all, the grand jury is a process where the basis for it is provided by the Fifth Amendment to the U.S. Constitution. And in federal cases, a grand jury must be used in all felony cases, although not in misdemeanor cases. In Michigan, a grand jury may be convened when it is petitioned by the Attorney General or two or more county prosecutors. It is typically used in crimes involving high-profile cases like former mayor of Detroit, Kwame Kilpatrick. It's also used in, for example, serious gang member activity, violent gang members, bank robberies, illegal possession of guns. So there's not a written set of rules that it can only be used in these cases, but those are the cases where it's more commonly used. I can tell you that I have tried an armed robbery cases here in Ottawa County, and obviously we didn't use a grand jury. So there's just a whole host of information that different prosecutors will look at. The movement, the trend, is to use the more adversarial process of a preliminary examination as opposed to a grand jury. Grand juries conduct their business, I don't want to say in secrecy, but the information is not required to be made public. The public doesn't need to know what information the grand jury is reviewing or who is being subpoenaed to the procedure. That is the way it's set out to be, where in a preliminary examination process, the defendant has every right to know exactly what the charges are, who the witnesses against him or her are. There is a hearing. The defendant has the right to present evidence if he or she so chooses. And then the determination is made by a judge, and all that is open to the public. So again, the movement, not just in Michigan, but across the country, is to use the more adversarial, open to the public process of a regular preliminary examination. And that's what we do for the most part here in Ottawa County.
But you brought up a very good point. If it's a case of maybe more than one jurisdiction involved with a case, maybe a grand jury is necessary because sometimes the prosecutors might have, I wouldn't say differing opinions, but this way it's one voice instead of maybe two or three or four different voices in the situation.
Correct. Yes.
All right, 395-1450, 395-1450. If you have a question for Ottawa County Assistant Prosecutor Juanita Bocanegra. The decision by a judge in Louisville to open the results of the proceedings in the Breonna Taylor case. The Attorney General of the state of Kentucky says that while the grand jury is meant to be a secret body, he'll comply with that judge's order to release the recording, saying it's obvious public interest in the case won't allow him to follow through on an ethical obligation to protect the information. It gets back to the point, and I think we brought about this a little bit earlier, Juanita, in our discussions about the prosecutor's office having to deal with public sentiment that might make things a little tough to try to do some things in your office that you feel need to be done.
Correct. Yeah. And public sentiment is a very valid consideration. Prosecutors are officials that are elected. So while there is an ethical obligation to always make the right call and do the things according to what is prescribed by law, there is also a duty to the community as a public government employee to be transparent with the community. And trying to balance that can at times be challenging. I can tell you that personally, our office was a little bit under fire recently. I don't know if you saw in the news the situation with the apple orchard and the video, the language that was used by individuals at that apple orchard when dealing with their migrant farm workers. We were questioned as to why ethnic intimidation charges were not brought. And I can tell you that the information that was made available to the public, both by the attorney that was representing the victim in that case and by the media, is not all the information that we have. There was much more to it. There was information that we didn't have that would have been necessary for the more serious charge of ethnic intimidation.
395-1450, 395-1450. If you have a question for Ottawa County Assistant Prosecutor and Judge candidate for the 58th District Court, Juanita Bocanegra. I'm going to ask you a question about debates. And I'm not trying to judge or put any judgment about what we saw last night in Cleveland. But as one who needs to be skilled as a debater, after all, prosecutors are trying to present the best case possible. How tough is it to try to not put the emotions in the situation of just being able to present what the case will be and not let the emotions get the better of you, as we may have saw in Cleveland last night?
It's hard, Gary. It's not an easy thing to do. I'm trying to hide the emotion, trying to keep the voice from shaking, trying to keep the tears from flowing, especially when we're dealing with cases that involve vulnerable victims like children, or in very serious cases of domestic violence and domestic abuse, especially in closing arguments. You know, I've told juries before, this is not a throwaway victim. This is a real person. And when you're describing, putting all the case together and summarizing all the evidence, and you're looking at photographs and you're describing what this victim went through, it is hard to kind of keep yourself together and not get teary-eyed and keep the emotion out of it. By the time the case gets to trial, the prosecutor assigned to the case, we have worked with those victims for months, sometimes years. It could take a year and a half or more before a case eventually gets to trial on the more serious cases. You've met with them many, many times. You've met with family members. It's inevitable that you are going to become attached to the case, and you are going to become attached to the victims and the witnesses that you've worked with for so many months, for so long.
We see it in the dramatic presentations of trials where the prosecutor or the defense attorney will use the emotion card to try to play on the jurors' emotions. That more of a dramatic license, or do you see that really in the actual trials that you might have to be involved with, especially maybe the defense attorney trying to play on the emotions of the jurors?
Oh, it's certainly done by both sides. And I guess I would be hesitant to say that it's something, that it's an intentional thing or that there is any intentional manipulation. I think we're humans. We're all humans, defense attorney, defendant, prosecutor, jurors. So when you see something harsh, when you hear a teenager testifying about the sexual abuse that they endured from a young age, any human is going to react to that. When you see the pictures of somebody that is violently beaten and they retell the story and they're crying because it's hard to relive that moment, it's hard not to get emotional. So I don't think that it's like an intentional, I'm going to try to pull on their emotions and manipulate the situation. It's just part of life. It's part of the process. And we try hard. I know I try hard. My colleagues try hard, like I said, to keep our voice from shaking and keep the tears from flowing. Even if we, cry before and after, we try very hard not to do that in front of juries.
Now, you would like to become the next 58th District Court judge on the November 3rd election, which makes it a little bit different than a circuit court judge. The circuit court judge in a criminal case, once a verdict has been handed down, administers the sentence for a particular crime in this regard. But sometimes a judge needs to basically have the stiff upper lip as well. Maybe not in the circuit court, a district court is what you're running for, but in a circuit court situation, I'm thinking of the Larry Nassar judge. She got a little bit emotional about the in the sentencing, and there were some who were saying, "Hey, wait a minute, there is a time for having the thoughts, but if you're a judge, you need to make the basis of the decision on the facts and not on the emotion as well," which is kind of tough, as you said, because judges are human too.
Yeah, absolutely. The judge's role is to take the law as it's written and apply it to the facts in front of him or in front of her. District court judges also hand down sentences. It's just for cases involving less than a year of punishment, a year or more than a year, I should say, goes to circuit court. But I have seen judges at the district court level also struggle to conduct themselves in a more professional manner. Not that getting emotions, or being emotional is unprofessional, but trying to not show that emotion in dealing with certain cases where somebody has died, for example, or again, where they've seen the evidence in front of them and it's a very serious case. I have seen judges struggle with that. And for the most part, they do an excellent job of just taking the law and applying it to the facts. And not showing that personal emotional struggle in the courtroom.
Also, not just the emotional struggle of a case particularly, but a judge also has to sort of keep the emotions in check when maybe one or the other attorneys involved may be saying things or doing things that are not, let's just say the bar would not be too happy about it.
Yes, and the judges are good at calling the attorneys out, sometimes, taking a recess or calling the attorneys up to the bench and having a sidebar conversation about that. If something is inappropriate, then it is the judge's responsibility to call that out. Whether the judge chooses to do that from the bench and in front of the jury and in front of the people in the public is one thing, or whether they decide to just call the attorneys up and talk to both of them. It's completely up to the judge. I think out of respect for the attorneys, usually the judges will call the attorneys up so as not to embarrass them, but to say you need to stop this behavior.
I'm sort of putting the human factor in your efforts to try to become a judge because, to be honest with you, if you are elected, you're going to be faced with these type of situations now with the robe on instead of just as on the prosecutor's bench or whoever is, you did some time perhaps with defending cases, but not as much in the prosecutorial area. So, case of listeners want to know how you would handle yourself and the decorum in a tougher situation. And to a certain extent, we expect that when we see a debate, we expect to see that as, that's sort of putting you in a little bit of a tough situation as well. If you got a question for Ottawa County Assistant Prosecutor Juanita Bocanegra, she is running for the 58th District Court Judge seat that'll be vacated by the retiring Susan Jonas. She'll be happy to take it at 395-1450, 395-1450. We're less than 5 weeks from the November 3rd election. Obviously, some people have already gotten their ballots and have started to make some decisions. We're seeing on a statewide level, two judicial candidates, one being an incumbent and one a newcomer, sort of joining forces to say, vote for us as a team to be on the Michigan Supreme Court. Of course, you're running alone in that regard. We saw the team aspect work, and I think it was 4 years ago, with two seats in the Ottawa County Circuit Court being up for grabs. Team aspect of campaigning for it, depends on the situation.
I think it depends on the situation. We have to remember that judicial candidates are required to run nonpartisan. So a judicial candidate is not able to run on the same, to promote like on the same mailer, for example, or to be on the same team with another friend that may be running for a different public office if the other office is partisan. So in the case we had 4 years ago with Judge Miedema and Judge Mulder, they were able to do that because they were both running a nonpartisan race, both for a seat in Ottawa County. One was for district court and the other one was for circuit court. In the case that we have this year, both candidates are running for a seat in the Supreme Court. So again, both running covered by the same guidelines. I would not be able to run, for example, with somebody else who may be running for the Senate or for prosecutor or any other public office. I have to run nonpartisan.
Okay, but I'm just asking whether or not it's something that you might be willing to consider maybe in another time, but we'll see. Let's get to a phone call or two. Good morning. You're on the air with judicial candidate Juanita Bocanegra.
Good morning. It's my understanding that when a case goes to circuit court, felony, it has to go through district court first and to see whether it's serious enough for that. But I was involved in a case where a man was being tried for murder, and then two other people were brought in to the court during the hearings that were later seen as innocent. The other one was proved. Now, why is that allowed that they can bring that right into the circuit court without going through district court? I'll hang up and get the comments.
Okay, thank you very much for the call.
So I want to make sure I understand the question correctly. And if the question is, why is it that there was another co-defendant that was charged and that perhaps didn't go through a preliminary examination hearing at the district court level, the only way that a case gets to the circuit court, in a murder case, for example, all proceedings must start at the district court level. So it's very possible, I don't know specifically what case this gentleman is referring to, but it's very possible that one of the co-defendants chose to exercise his or her right to a preliminary examination and actually run the hearing and find out what kind of evidence the prosecution had against him or her, where the other co-defendant may have very well chosen to waive his right to a preliminary examination, and the case automatically would have been bound over to circuit court, again, only if the preliminary examination was waived. That needs to be done with the permission of the prosecutor, but because there are cases in which a defendant may say, I know that there's going to be enough evidence here for me to be bound over to circuit court, and I want to do that. However, the prosecutor may say, there is evidence that I want to preserve, evidence that I want to run the preliminary examination. So with regard to this gentleman's question, again, the only way I can think of that it got to the circuit court without a district court hearing is there was a waiver of a preliminary examination involved, that they consented to that.
And we've seen that especially in the dramatic versions as well. Good morning. You're on the line with Ottawa County Assistant Prosecutor Juanita Bocanegra.
Good morning. I guess I'll just ask. The show called Bowl on that other station, does that stuff happen as far as when you pick juries and stuff? Do you examine these people, or how does it work? And I'll hang up and listen.
I appreciate the call. Thank you.
Thank you. Yes, I'm not sure what show you're referring to, but with regard to your question, whether we examine people to serve on a jury, yes, we do. During voir dire or jury selection, there are a group of individuals that are summoned to the court, and from that group in a district court trial, we have 7 jurors that are selected to be in the box, and circuit court usually 13, but the purpose of that is to allow both the prosecution and the defense to ask questions of the juror with the end goal in mind of selecting an unbiased jury. So yes, we examine the jurors. We will ask them, for example, if they've ever served on a jury before, if there was anything about that experience that would interfere with their ability to be fair and impartial in this case, whether if it's a domestic violence case, whether they have been victims of domestic violence or know anyone that has been a victim of domestic violence, whether they've had any negative interactions with the police. Oftentimes, if the defendant is a person of color, I will always ask, we can see it's very obvious that this individual is a person of color. Can you be fair and impartial? Anything about that? So we ask questions. Jury selection can take anywhere from 15 minutes up to 3 hours or more in our more serious felony cases up in circuit court. Sometimes the judges will say, I'm going to conduct part of that examination or ask some of those questions, trying to speed up the process. But yes, we do ask those questions, again, with the end goal of picking a fair and impartial jury to both sides.
Juanita, I'll give you the last word since we're coming up towards the end of the half hour. What are you running for, and who can vote for you in this particular election?
Thank you. I'm running for judge of the 58th District Court here in Ottawa County. It is a county-wide race, so any Ottawa County resident may vote for me. In addition, any resident of the city of Holland, even those that live just outside the county line in Allegan County, if it's within the city of Holland, they will see my name on the ballot. I respectfully and humbly ask for the people's vote. I will say that I am endorsed by Judge Susan Jonas, who's our retiring judge, and I'm very honored by that endorsement. She's worked with both candidates, and she has chosen to endorse me. So I think that is very meaningful, especially to people who may not know either one of us. To have that endorsement from the retiring judge is huge. I'm endorsed by every commissioner in the county, so every one of you can ask your commissioner, regardless of where you live in Ottawa County, why they are endorsing me. And I think that is significant, as well as the endorsement from our Sheriff, Steve Kemker, and Prosecutor Ron France, and several other elected officials and community and business members.
And
Thank you.
And the judgeship, even though it's in the 58th District Court, you'll be working mostly out of Holland, right?
Hopefully, I will be working mostly out of Holland. There is always a possibility that the judges that are currently on the bench may want to move around, or that Judge Cano, who's our chief judge, may want to move the judges around. So far, everybody's indicating that they want to stay where they're at. So it's very likely that the seat will be here in Holland in the very chambers of Judge Jonas.
Sounds good. Juanita Bocanegra, thank you very much for joining us today on WHTC's Talk of the Town. Wish you well on the campaign. And, of course, November 3rd is the election. Thank you for joining us this morning.
Thank you, Gary. Appreciate it.
And that is Juanita Bocanegra of the Ottawa County Prosecutor's Office.